Hello everyone, kamusta? I hope you're all doing fine. Welcome back to the channel. This is the House of Law. Now before I continue, I'd like to apologize for the lag or the latency. My mouth is not coordinating with the audio. I don't know how to fix the encoder so that it will be more in sync. But in the meantime, just follow the voice and from time to time check this window if I'm still here. Also, before I continue, I'd like to say thank you very much for watching my videos and for subscribing to my channel. Now, if you are new to this channel, I am Attorney Al Jumrani. I make videos about the law, about law subjects, and about law-related issues. I hope you will enjoy your stay here. I hope you are learning a lot. And if you are enjoying and if you are learning, please consider subscribing and click that notification bell so that you will be notified in case I upload a new video. So anyway, let's continue. So today's video is the lawyer in the courts. This video is supposed to help us understand the specific or the relevant canons and rules of the Code of Professional Responsibility that are applicable to the duties of the lawyer to the courts. We will also look at decisions of the Supreme Court on the matter. Okay, now to guide us in this lecture, let's ask ourselves the following questions. What does a lawyer is an officer of the court mean? Are these ethical standards applicable also to lawyers who do not appear in courts? Between the lawyer's duties to the courts and his duties to his client, what or which are superior? Okay, first let's look at some pictures. Okay, now this first photo is of course very familiar. You know her. She's Viola Davis in her very popular and award-winning role as Annalise Keating in the TV series How to Get Away with Murder. Now, I think this picture sums up, the primacy of the lawyer's duties to the courts. Look at her. She's well-dressed. Her confidence, her posture only, shows that she is doing her best. She comes to court prepared. She's doing her best to win a case. The success of her case rests in the hands of the court. So therefore, we are like suitors. And so may the best lawyer win, so to speak. Okay, now the second picture shows also a very familiar scene. And this is Christine Baranski in her well-loved character as Diane Lockhart in The Good Wife. So in this picture, you will see that Diane Lockhart has a client and she is also trying to convince the court so that the court will rule in favor of her client. So as a litigating lawyer, you will find yourself at a crossroad, torn between your duties to the court and duties to the client. So this conflict or this clash is resolved right here, right now, okay, by the Code of Professional Responsibility. So let's now look at these canons and rules and see how far or how serious these duties are. So canons 10 to 13 of the Code of Professional Responsibility deal with the ethical standards that lawyers must observe in the discharge of their functions as officers of the court. These canons mainly apply to litigation and trial lawyers or those appearing before the courts and representing clients. However, lawyers who do not litigate are also urged to demonstrate the same respect towards the judicial institution, orders of the courts, as well as incumbent judges. But why? The simple reason is Canon 1 of the Code of Professional Responsibility, which extols all lawyers to uphold the Constitution, obey the laws of the land, and promote respect for law and for legal processes. Respect for the courts and court orders is included in the respect for law and for legal processes. Now, when a lawyer litigates, he is constantly confronted with the challenge of balancing the interests of his client and his duties as officer of the court. A lawyer's natural instinct is to win the case for his client, but is this his professional instinct as well? Canon 10 and its rules clearly put the duty of the lawyer to the courts above his duty to the client. A lawyer is first and foremost an officer of the court. His duties to the court are more significant than those which he owes to his client. Thus, should there be a conflict between his duty to his client and that to the court, he should resolve the conflict against the former and in favor of the latter, his primary responsibility being to uphold the cause of justice. So let's look at Canon number 10. Canon 10 states that a lawyer owes candor, fairness, and good faith to the court. Rule 10.01 states that a lawyer shall not do any falsehood nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. Rule 10.02 states that a lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language or the argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by repeal or amendment, or assert as a fact that which has not been proved. Now, finally, Rule 10.03 states that a lawyer shall observe the rules of procedure and shall not misuse them to defeat the ends of justice. So let's explain these three rules. So Canon 10 provides that a lawyer owes candor, fairness, and good faith to the court. This requires that a lawyer acts with the highest standards of honesty, fair play, and nobility. But how can a lawyer be true to this directive? First, he should not suppress material and vital facts which bear on the merit or lack of merit of a complaint or petition. And this applies even if that fact or evidence, will help the other party win the case. You're doing it not for the other party. You're doing it not for yourself, but you're doing that for the court. Second, in his pleadings and pronouncements in court, a lawyer shall not do any falsehood nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. A lawyer should refuse or decline any instruction from his client to commit such falsehood or deception. Now, there's been an old joke about lawyers. They say lawyers are liars because they can be paid to lie in court. But then that is not true. Let's just keep it as a joke, no? So let's not be the realization of that joke. So a lawyer is not a liar. Third, a lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language or the argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by repeal or amendment, or assert as a fact that which has not been proved. Thus, as a lawyer, you must do your legal research well. Do not just rely on your old notes. Do not just rely on an old decision, because some of these, if not all of these, may have already been, modified or worse, abandoned. So always, check the latest. Always check also the status of laws, because they may have already been, as I've said, abandoned or changed. Okay. Similarly, lawyers should show candor, fairness, and good faith to the court by observing the rules of procedure and not misusing them to defeat the ends of justice. It must be emphasized that the rules of procedure offer innumerable opportunities and means for delay and to defeat the ends of justice. So, as a lawyer, will you use these technicalities to delay the case for the benefit of your client, or to frustrate the ends of justice, or to sidestep certain requirements just so you will be able to win your case? So, a lawyer must be careful and avoid abusing these rules of procedure. Delaying the case and court proceedings by using everything in the rule book is a breach of a lawyer's duty to the courts. Now let's look at illustrative cases. Now these are just two of many, but I cited these because they are relevant to what has just been discussed. So in Crisostomo versus Nazareno, the respondent lawyer was suspended from the practice of law for 1 year. For what reason? for making false declarations in the certification against forum shopping. If you will remember your rules of court, in a certification against forum shopping, the petitioner or the complainant states that there are no pending cases involving the same parties, the same issues, or the same causes of action. But here, the lawyer made a falsehood by not stating that a case is already pending between the parties before the HLURB. So that's why an administrative complaint was filed against the lawyer, Attorney Nazareno, and so the court found that he was in fact guilty of violating Canon 10 by engaging in forum shopping, or by committing a false statement in his certification against forum shopping. Okay, the next case is Festin versus Zubiri. Here, the respondent lawyer was suspended from the practice of law for 3 months. For what reason? For defying a TRO and filing several manifestations to pray for the execution of the judgment pending appeal. Okay, the manifestations here were filed purposely to sidestep the requirement of notice and hearing. That's why the other party was not informed or notified of the manifestations, as well as the prayers sought by the client of Attorney Zubiri in this case. And when, of course, the opposing party knew about this strategy and tactics filed by Attorney Zubiri, okay, the other party filed an administrative case on the ground of violating Canon 10 because of using the technicalities or the technical rules of procedure in order to frustrate the ends of justice. Okay, now let's talk about Canon 11. So Canon 11 provides that a lawyer shall observe and maintain the respect due to the courts and to judicial officers, and should insist on similar conduct by others. So let's look at the specific rules under Canon 11. So Rule 11.01 provides that a lawyer shall appear in court properly attired. Rule 11.02 states that a lawyer shall punctually appear at court hearings. Rule 11.03 states that a lawyer shall abstain from scandalous, offensive, or menacing language or behavior before the courts. And Rule 11.04 states that a lawyer shall not attribute to a judge motives not supported by the record or have no materiality to the case. And finally, Rule 11.05 states that a lawyer shall submit grievances against a judge to the proper authorities only. Okay, now let's explain these rules. So first, let's look at this picture. Most of the time, lawyers and judges argue in court. I mean, it's not just lawyers against lawyers or the opposing counsels arguing in court, but also the judge could engage in a debate or an argument with the lawyer. Now, this may not be unavoidable, but of course the code requires that lawyers should always maintain that respect to the court, particularly this. So Canon 11 provides that a lawyer shall observe and maintain the respect due to the courts and to judicial officers, and should insist on similar conduct by others. And if you are a lawyer and you have a client, you must always remind your client that we are here before the court. We are here asking the court for some affirmative action or affirmative relief. That's why we must maintain and accord the court the respect that it deserves. Okay, so this code may be applicable, primarily to lawyers, but by extension, clients are also bound, by this Canon 11. So aside from the usual, using only courteous language in pleadings and in oral arguments, a lawyer also shows respect to the court by appearing in court properly attired and by appearing punctually at court hearings. Also, lawyers are called upon to obey court orders and processes. Court orders, however erroneous, must be respected and should be challenged only in the proper forum. And now, a lawyer may possess more knowledge of the law than the judge, but discipline and self-restraint on the part of the members of the bar are necessary for the orderly administration of justice. Judges never claim to be perfect. They were appointed because at the time when they were applying or they were appointed, they have exhibited the qualifications as well as the credentials for appointment, okay, to the bench. And these credentials or qualifications are not limited to or are not solely based on academic qualifications. Now, a lawyer, because of his extensive years in practice, may have acquired more knowledge than a judge. Okay? But that doesn't mean or that doesn't give the lawyer the license to insult or to act like he can humiliate the judge for the judge's lack of experience than the lawyer. You see, the superior knowledge of the lawyer also does not give him a license to insult or antagonize the judge. In case of serious grievances, a lawyer shall submit these grievances against a judge to the proper authorities only, meaning the Supreme Court, which has administrative supervision over all courts and the power to discipline judges of lower courts. Okay, so it's not nice to hear lawyers complaining outside of court about, the decisions of the judge and attacking the decisions based on the personal characteristics or credentials of the judge. A decision must be reacted to based on the argument stated therein. Hate the message, do not hate the messenger, so to speak. Okay. So let's look at some illustrative cases. So in Falsis versus Civil Registrar General, which of course a very celebrated case because it sought to declare unconstitutional Article 1 of the Family Code, which limits marriage only to a man and a woman. But we are citing this case because of a very interesting incident. So in a resolution dated July 3, 2018, petitioner's lawyer, Attorney Falsis, it was petitioner. So petitioner lawyer was found guilty of direct contempt and was admonished for his failure to observe the required decorum by appearing in a casual jacket, cropped jeans, and loafers without socks during the preliminary conference. And where was this preliminary conference? It was before the Supreme Court. I mean, of all places, if you're appearing in the Supreme Court, you must consider that as the prime of your career, to be appearing before justices of the Supreme Court. Now, many lawyers like myself, I haven't even argued before the Supreme Court. But here he had that very unique and very special opportunity and chance to argue before the Supreme Court, and yet he went there and appeared in a casual jacket, cropped jeans, and loafers without socks. So, of course, this was not missed by the Supreme Court, and Attorney Falsis was cited in direct contempt of court. Okay. Now, another case is Sanggalang versus Intermediate Appellate Court. Here, petitioner's lawyer was suspended from the practice of law for 3 months. For what reason? For filing a motion for reconsideration with derogatory statements and recourses to argumenta ad hominem. So, Sanggalang here lost the case before the Supreme Court, and through the lawyer, Sanggalang filed a motion for reconsideration. But instead of just attacking or pointing out the errors in the assailed decision, the lawyer there went into a tirade against the court, accusing the court of bias and, of course, accusing the court of twisting or raping the law and all that. So there were insinuations which, of course, attacked the personality of the justices as well as the Supreme Court as a whole. So that's why the lawyer here, who was a retired judge, was suspended from the practice for 3 months, because according to the Supreme Court, that was clearly a violation of Canon 11 of the Code of Professional Responsibility, which directs lawyers to remain respectful and courteous to the court, even in their pleadings. Okay? Now, let's look at Canon 12. Now, Canon 12 provides that a lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Let's look at the specific rules under Canon 12. Rule 12.01 provides that a lawyer shall not appear for trial unless he has adequately prepared himself on the law and the facts of his case, the evidence he will adduce, and the order of its proference. He should also be ready with the original documents for comparison with the copies. Now, Rule 12.02 states that a lawyer shall not file multiple actions arising from the same cause. Rule 12.03, a lawyer shall not, after obtaining extensions of time to file pleadings, memoranda, or briefs, let the period lapse without submitting the same or offering an explanation for his failure to do so. So, take note that these are more of for the orderly conduct of proceedings in court. So a lawyer should appear prepared, a lawyer should be ready with his documents, and also when asked to file pleadings, then these pleadings should be filed within the period granted. Okay, in addition, we have Rule 12.04, which states that a lawyer shall not unduly delay a case, impede the execution of a judgment, or misuse court processes. Rule 12.05, meanwhile, provides that a lawyer shall refrain from talking to his witness during a break or recess in the trial while the witness is still under examination. Rule 12.06 provides that a lawyer shall not knowingly assist a witness to misrepresent himself or to impersonate another. And lastly, a lawyer shall not abuse, browbeat, or harass a witness, nor needlessly inconvenience him. Okay? So next is Rule 12.08, which states that a lawyer shall avoid testifying on behalf of his client except in the following instances. So first, on formal matters such as mailing, authentication, or custody of an instrument and the like, or on substantial matters in cases where his testimony is essential to the ends of justice, in which event he must, during his testimony, entrust the trial of the case to another counsel. Alright. Now, what are these rules about? Well, first, Canon 12 speaks of the duty of the lawyer to assist the court in the speedy and effective administrative of justice. In relation thereto, a lawyer should come to court adequately prepared. Also, a lawyer should refrain from committing the following. So first, forum shopping, which is defined as the practice of filing multiple actions arising from the same cause. Remember the case that I mentioned earlier involving Attorney Nazareno. Okay. Next, abusing extensions of time granted by the court. Now, for new lawyers, first few things that they have filed is a motion for extension of time. Now, motions for extension of time are not altogether bad, but if you ask for some extension of time, ask it in all good faith. It should not be for the purpose of delay, but rather because you just really needed time and what you're filing or what you're going to file is meritorious and that could find that material in the resolution of the case. But unfortunately, some lawyers find that as a means to delay and to procrastinate. Okay, so the better practice is that once you get an order or once you have been directed to do something or file something, do it immediately once you return to your office or once you get home. Okay, instead of waiting and then later on just ask additional days because yun, tinamad kang gawin yun. Kaya humingi ng extension. That's a bad practice and it will become so ingrained in you that even the most simple cases will just drag on because of the number of extensions that you ask from the court. Okay, another thing that should be avoided by the lawyer is to delay a case, impeding the execution of a judgment, or misusing court processes. Okay. Also, talking to the witness while the witness is still under examination, assisting a witness to misrepresent himself or to impersonate another, abusing, browbeating, or harassing a witness or needlessly inconveniencing him, and lastly, to testify in behalf of his client except for the cases cited under Rule 12.08. Okay. A lawyer is in the best position to decide whether the case of his client deserves appellate review. If a lawyer is honestly convinced of the futility of an appeal in a civil suit, he should not hesitate to inform his disappointed client that most likely the verdict will not be altered. So he should advise his client to accept the judgment of the trial court and thus accord respect to the just claim of the opposite party. Sometimes there is merit in just accepting defeat, because sometimes that would mean less cost, and of course that would mean a closure to this stressful saga in their lives. And it really is about accepting the reality that some things you can change, or that if you can change them, at least try to make the change acceptable to both parties. All right. Nonetheless, a lawyer should not, notwithstanding the fact that the lawyer believes that it would be futile to file an appeal or to pursue further proceedings or cases, a lawyer should not, solely on his judgment, let the decision become final by letting the period to appeal lapse. He must inform the client of the adverse decision and of his candid advice in taking appellate review thereof. And that he must do this within the period to appeal so that the client can still decide whether to pursue appellate review. Alright? Now, illustrative cases. The first case is Lopez versus Limos. So, here the respondent lawyer was suspended for 3 years for ignoring orders to file comment to the administrative complaint against her, which caused undue delay in the resolution of the case. And this was considered a violation of Canon 12. So, this case is very interesting because the lawyer, Attorney Limos, was charged by a former client for, I think, negligence in the handling of her case. And the administrative case was filed before the Supreme Court, and the Supreme Court sent Attorney Limos several directives or orders to file her comment and to explain to the court why no disciplinary sanctions should be imposed upon her, but she did not respond. And because of that, the court had to refer it to the IBP so that the Integrated Bar of the Philippines could conduct further investigation. And again, she did not cooperate or participate in the proceedings before the IBP. If you are a lawyer and you have been directed to file a piece of paper, even though you feel that this piece of paper is useless as to you, but it is something that is demanded by the court, so you must comply. Now, if you can't comply, then at least tell the court why you are not submitting or filing it, because at least the court will be informed of your position on the issue at hand. So you can waive that right so that the court can just can just proceed to resolve the case. But to ignore the order of the court is really an act of disrespect. All right. Next illustrative case is the case of Buena Vista versus Deloria. So here, respondent lawyer was suspended for 2 years. For what reason? For committing forum shopping by filing successive cases before the RTC, then HLURB. So Canon 13 provides that a lawyer shall rely upon the merits of his cause and refrain from any impropriety which tends to influence or gives the appearance of influencing the court. So what are the different rules under Canon 13? So Rule 13.01 states that a lawyer shall not extend extraordinary attention or hospitality to, nor seek opportunity for cultivating familiarity with judges. Rule 13.02 provides that a lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. Sounds familiar? Well, yeah, this is exactly the rule on Sub Judice. But anyway, more on that later. Now, Rule 13.03 states that a lawyer shall not brook or invite interference by another branch or agency of the government in the normal course of judicial proceedings. Okay, a lawyer should always rely on the merits of his case. And as provided under Canon 13, he should avoid impropriety or the perception of impropriety which tends to influence or give the appearance of influencing the court. Okay, now never mind that some clients asking a lawyer if that lawyer has connections. Your answer should always be no. even if you know the judge, or you know the members of the court in case of appellate courts. Always say no, because that should not be the criteria or criterion for your being engaged. Okay, you are hired to, you know, to represent and to file or defend the case for and on behalf of your client. Peddle influence or to fix the case, that's not part of our job description. Okay. In relation thereto, a lawyer shall not extend extraordinary attention or hospitality to, nor seek opportunity for cultivating familiarity with judges. Fraternizing with judges should be reduced, if not totally eliminated. And this applies even if the judge is a classmate, a schoolmate, a brother, or a sister in a fraternity or sorority, respectively. Because you don't win a case based on connections. You are not supposed to win a case based on connections, notwithstanding public impression or, you know, personal experience about the effect of friendship to cases. You know, it should not be the rule, and that should be discouraged. Alright, a lawyer should also not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. Otherwise, it would violate the Sub Judice rule. Lastly, a lawyer should not brook or invite interference by another branch or agency of the government in the normal course of judicial proceedings. Alright, so let's discuss the Sub Judice rule. Sub judice is a Latin term which refers to matters under or before a judge or court, or matters under judicial consideration. In essence, the sub judice rule restricts or prohibits comments and disclosures pertaining to pending judicial proceedings. The restriction applies to litigants and witnesses, the public in general, and most especially members of the bar and the bench, meaning to say lawyers and judges. Its purpose is to avoid prejudicing the issue, influencing the court, or obstructing the administration of justice. Let the discussion happen inside the courtroom. Let the legal fight happen in the pleadings, but not in media, not in coffee shops, or not in gatherings of lawyers. The public has no business knowing about these details. Okay? Alright, let's look at some illustrative cases. So first is Dumlao Jr. versus Camacho. So here, respondent lawyer was meted a suspension for 2 years for approaching a judge to gain influence and receive a favorable outcome for the client. So here, the suspension was just 2 years, but the Supreme Court noted that, you know, while the case was pending, in another case, Attorney Camacho was ordered disbarred for a more serious offense. Although he was already disbarred, the Supreme Court said that the penalty of 2 years must still be, you know, placed in his record, and should he ask for reinstatement, the penalty of 2 years suspension should first be, you know, administered and meted. Okay, the next case is of course very familiar. This is in re show cause order against Maria Lourdes Sereno, and this is AM number 180601-SC, dated July 17, 2018. And here, respondent lawyer, ex-Chief Justice Sereno, was reprimanded for violating the sub judice rule by making public utterances against the quo warranto proceedings filed against her, which tended to arouse opinion on the matter. If you still remember, ex-Chief Justice Sereno appeared in several, you know, media outlets, shows, and even gatherings of lawyers, of NGOs, and even I think public officials. No? She appeared there and she attacked the quo warranto proceeding against her, calling it as a travesty, the control that the executive department has over the Supreme Court. Of course, this did not sit well with the Supreme Court, and the Supreme Court held her administratively liable under the Code of Professional Responsibility, particularly on the rule against sub judice. But here, she was only reprimanded. Okay, in the case of other lawyers, that would have meted the penalty of suspension. But here, she was only reprimanded because, according to the Supreme Court, well, she had already been removed through a quo warranto proceeding, And so to suspend her from the practice of law would be too harsh, because that would mean she cannot go back to the practice of law. Okay, when in fact she might need that after, of course, losing her seat or losing her robe as a justice of the Supreme Court. Alright, now as a concluding statement, I'd like to cite what the Supreme Court said in Montesilio versus Gica. Okay, 158 Philippine Reports, page 443, 1974. It is the duty of the lawyer to maintain towards the courts a respectful attitude. As an officer of the court, it is his duty to uphold the dignity and authority of the court, to which he owes fidelity according to the oath he has taken. Respect for the courts guarantees the stability of our domestic institutions, which, without such respect, would be resting on a very shaky foundation. Nice words. And these are nice reminders for lawyers, for would-be lawyers, and even for clients. So that's it. That ends my video. Thank you very much. I hope you learned something valuable about legal ethics, particularly the duties of the lawyer to the courts. So by the way, please don't forget to subscribe to my channel. This is the House of Law. You can also find me on Facebook. My page is Attorney Al Jumani. So if you enjoyed this video, please drop a like. I'll see you in my next video, and laging tatandaan, isip ay buksan, alamin ang batas.